A warm welcome from the heart of Munich at the Data Protection Café. Today's topic, background checks on applicants, indeed. Employers frequently and often express interest in conducting thorough and comprehensive background checks on applicants, particularly regarding their financial and personal circumstances, as well as their background and history. But under what exact data protection conditions are these checks even permissible? More on that in today's specific video. For background checks, it is first important to note that they involve the processing of personal data. This is generally undisputed, so in order to address this, we need a justification, particularly consent or legitimate interest in this context in practice. Furthermore, the principle of purpose limitation applies to the respective examination procedures. Let's take a closer look at them individually. Let's start with social networks. And more specifically, is an HR department allowed to check what applicants have published on social media platforms? In particular, the principle applies that such checks are, in general, allowed and acceptable on professionally oriented networks like LinkedIn or Xing. On privately oriented social platforms like Facebook, such as Facebook and other similar platforms, this is considered impermissible, for example. Then there is the offer available on the internet to have all published data about a person automatically, efficiently, and comprehensively compiled. In this context, particularly with regard to Article 22 GDPR, the consent of the affected applicant is generally required. In my opinion, it is indeed generally questionable whether one can truly give voluntary consent to the processing of this data. And thus, it raises the question for me whether there is even a legitimate basis in any conceivable way for this type of data processing at all. Now let's look at the area of certificates of conduct. Not every country has this concept, but in Germany there is the concept of certificates of conduct. This means that the relevant documents are officially issued by the state authorities to clearly indicate whether there are any prior criminal convictions. Here too there is a distinction between an extended certificate of conduct and a regular certificate of conduct. Here, the principle applies that the submission of a certificate of conduct is generally not considered necessary for applicants. Only when the hiring process reaches a concrete decision, essentially after the first round of interviews, evaluations, and assessments is completed, is it permissible or even required to request a certificate of conduct for positions where there is a special legal interest or a legal requirement. This ensures that all candidates meet the necessary legal standards. Specifically, if they want to hire someone who works in critical areas in any way, such as security, IT, or in any way comes into contact with financial flows, the submission of relevant certificates of conduct is considered entirely and absolutely permissible. And then in other areas such as childcare, the submission of certificates of conduct is also legally required. When we look at credit or Schufa reports, that is, the research regarding a person's financial circumstances in greater detail, this should not be part of the application process. Only after the hiring decision has essentially been made, in justified exceptional cases, particularly in positions dealing with financial flows, is it permissible to obtain such a report, as well as in exceptional cases? Then, HR departments often choose the method of contacting the previous employer to ask about their detailed and relevant experiences with the applicant, such as their work performance and behavior. Here too, such contact is only permissible with the prior, explicit, and written consent of the affected applicant given in advance. To quote Matthias Claudius, the greatest honor one can bestow upon a person is to place one's trust in them. And thus, in most cases, it is generally possible for the employer to get a comprehensive picture of the applicant through the submitted application documents and certificates. Only in exceptional cases are inquiries with previous employers permissible based on the consent of the individual concerned. A search in professionally oriented networks like LinkedIn and other similar platforms is possible. The submission of certificates of conduct is typically possible when the hiring decision has usually been made and a special position, e.g., security IT finances are given or, for example, are legally required when working with children, such as what else happened? The Pharmaceutical Association criticizes patient rights with regard to the European health data space in detail. More on that in the link and thoroughly. Enjoy reading for you.